Hi, I'm Dave Miranda, General Counsel and past President of the New York State Bar Association. Welcome to Miranda Warnings. You have the right to remain listening. On this week's episode of Miranda Warnings, we're discussing the issue of cameras in the courtroom. We're joined by two guests taking different sides of the issue of whether we should have cameras in the courtroom. We have Daniel Novack, who supports cameras in the courtroom. He's the Associate General Counsel at book publisher Penguin Random House. He is also a co-chair of the New York State Bar Association's Media and Law Committee and writes often on First Amendment and freedom of the press issues. He also has a podcast called Slander Town. Welcome, Daniel.
Thank you very much.
I'm hoping that today we won't have anything that would be worthy of Slander Town.
Full indemnity.
Our second guest is Norm Effman, who opposes cameras in the courtroom. He's the public defender in Wyoming County and the executive director of the Wyoming County Attica Legal Aid Bureau. He is also a member of the New York State Bar Association's Criminal Justice Section and a past member of the New York State Bar Association's Executive Committee and former chair of the Bar Association's Mandated Representation Committee. Welcome, Norm.
Pleasure to be here, David.
It is great to have you, Norm. I have some questions for you guys. I'm going to start with Daniel. In New York State, we already permit, to a certain extent, cameras in the courtroom for parts of some proceedings. Why should we remove the restrictions and have a much more liberal cameras in the courtroom?
Well, New York is somewhat of an outlier nationally on this issue. Across the 50 states, there's a variety of we'll call camera regimes. Some are extremely liberal, like Florida, and then many are in between and allow cameras in the courtroom at the discretion of the judge or sometimes the parties. New York is one of the only states that just has an absolute bar on cameras for anything where there's testimony, essentially. So we do have them in the appellate division and the Court of Appeals, but at the trial level, it's invisible, it's absent.
Right. So in New York, it's permitted for certain aspects of proceedings. Judges often allow coverage of arraignments, opening and closing arguments, appellate arguments, certainly. What's restricted is cameras to protect when witnesses are providing testimony, whether it be cross or direct testimony. And that's presumably designed to protect the witnesses. Norm, maybe you could say, why is it important that we have restrictions on public recording of witness testimony?
Well, David, first of all, which side of the coin I'm on, I'm not totally opposed to cameras in the courtroom. The big thing that most public defenders or most defense lawyers are concerned about is whether there's a requirement that there be consent by the parties before cameras are allowed in. That's the primary issue. There are times that cameras in a courtroom can be favorable. As far as witnesses go, the issue is one, will cameras in the courtroom intimidate some witnesses? Will they be reluctant to testify? Is there a safety issue involved? In order to, we realize these are open courtrooms. We realize that the press is allowed in, so that's not the issue. But cameras, at least in my mind, in today's day and age, create a whole different mental set as far as who's watching and how much am I in jeopardy because of what's being broadcast around the world?
Yeah, so, testifying in court for the average person is probably a very anxiety-ridden and harrowing experience for just about anyone. And so why would we want to permit recording and publishing this without the witness's consent, Dan?
Because there are courts, they belong to the public. And like you said, public access is a bedrock of our legal system. And the pandemic sort of exposed that, we'll call it the edifice of it, because we couldn't get into the courtrooms. So we've been operating in this sort of experimental access program that was born out of necessity for the last couple of years. But it exposed that the offer to go to court is a really hollow one for a court watcher, or those that would like to watch. for a variety of reasons. One, who is available during business hours that has work, they can't be there. There's some people that don't have geographic access. There's people that have disabilities and can't physically get there. So the notion that, well, our courts are open, well, it's only if you can take a Wednesday afternoon off, or I should say all of Wednesday off, to go and watch. I happened to go down to the courthouse, the Southern District, to watch the first day of the Sarah Palin versus New York Times trial. And I had to take off work to do it. And so there's a consequence to that, right? And I consider myself fortunate that I'm one of the people that could take a day off and call it a personal day, whatever you want. So that's part of the answer.
So you're saying what? So to make it more convenient,
it's
to be recorded. I mean, so
it's a question of parity. I don't believe that people that want to observe our courts should not have the same access predicated on whether or not they can physically make the time or have the access, have a car, whatever they need to get there. If our courts are truly public and belong to the public, they should be open to it in that way. And I am cognizant of concerns that witnesses could have. And I'm going to hold up Florida as the jewel of cameras in the courtroom, because I think they do a great job. They've done it for 40 years now. There's all these exceptions that are built in that are designed to protect vulnerable people. And so I just want to kind of offer a very large caveat at the very beginning that if you're talking about a sexual abuse case involving children, no, I don't believe that cameras are appropriate for a vulnerable child witness there. So there are certainly are cases that beg for more protection of vulnerable witnesses. But in your average civil trial, I do not agree that people can't get over a camera. In fact, they're quite unobtrusive compared to what they used to be. The system that many of the states have are these sort of live streams. I don't think you can really see the camera. It's kind of, it could be a sort of a wide eye lens up top. So yes, people are aware of them. I'm not going to, they're not, but it sort of melts away as a concern after a few minutes and people settle down. And the trials that we've had the fortunate ability to watch over the years, I don't think there's been any obvious sort of showmanship for the cameras. I
think that's subject to opinion, right? So, and I want to let Norm chime in, but I've got a question for you because you mentioned Florida's had this for 20 years. Do we have any empirical studies that show that because Florida has had cameras in the courtroom for 20 years, that the citizens of Florida have a greater understanding of our justice system as compared to a state that doesn't? Has their understanding of our justice system improved or not improved, or do we have any empirical evidence of the impact of that?
So Florida, I believe their cameras policy turned 40 about 9 years
40.
ago,
Okay.
right? So it's actually closer to 50 years, I think, at this point. There was a big study done about 9 or 10 years ago by the Florida court system as a look back, and they found all sorts of laudatory effects. And more than that, more importantly, in my view, is that all of the fears that people had cited never came to pass. There's been no movement to retrench this in Florida or other states that have opened up their courtrooms. So the fears that lawyers would sort of act for the cameras, that witnesses would shy up, all these things, it never came to pass. And so the states that have done it, the proof is in the pudding. They haven't had a retrenchment of this. And I want to just kind of tweak your question a little bit, because I don't care how people use it. It's a public good. So I hope that people will watch trials and gain a better understanding of the legal system. That's why I watch them. And I think millions of people are watching for that purpose. But if someone wants to put it on TikTok, that's the consequence of living in a free society. And so I don't think it's the burden of people who want to promote the public good to substantiate that the public will use it in the best possible way.
Yeah, right. Of course. And I want to talk about some of the ways that it may or may not be used. But you mentioned the proof is in the pudding. And so I want to give Norm a chance to talk. I know he loves pudding. But Norm, tell us why should New York be more like Florida? If it's working so great in Florida, why should New York be behind Florida?
I was going to ask Amber Heard, but that's another issue.
Yeah, right. I mean, I want to talk about that as well. But tell me, Dan says it's been fine for 40 years. Why can't we do it here in New York?
Well, the real issue, as I see it, is where the emphasis should be. And I'm dealing specifically with criminal cases at this point, because there are different issues when you come to family court, and a whole different world. Because the reason legislation proposed would include town and justice courts at some point. So that's really interesting to me. But it's the balance that we have to achieve. And what is the most important part of our criminal justice system? Sure, public access. All right. So the public has a right to know. I understand that, and I agree with that. And of course, we've always had public access. I think the whole cameras in the courtroom bit started off with the Lindbergh child case, where the cameras went crazy and just totally disrupted the procedure. There was the Hauptmann case, as I recall. And that started a debate as to whether we have to limit the amount of distractions that can occur as a result of publicity on high-profile cases. But the balance in my mind is the public's right to know and the right to a fair and impartial trial. And in my mind, the criminal justice system especially has to focus on the right of a defendant to a fair trial. And if that is any way impeded by this process, if it affects the way lawyers act, if it affects the way judges make decisions, if it affects the way witnesses will testify or not testify, it's a major problem. We're dealing, for example, with finally understanding how implicit bias can create a lack of a fairness in jury selection. This is simply another factor that can add to the difficulties in ensuring that there's a fair process where outside factors are not impacting what occurs in the courtroom. We have a very special setting. We play with very special rules in a courtroom. It is not the common understanding of why isn't the defendant telling his or her side of the story, which would be anticipated if someone were accused of a wrongdoing. And so the judges, through instructions, have to continue to emphasize that the burden is on the prosecutor. The defendant has no burden. He has no duty to explain anything. These are difficult concepts for lay individuals to really achieve in rendering a verdict. And to add another difficult factor, and that is the whole world is watching, can have an impact in some cases. And that's why I think the important thing is not so much whether we have cameras or not, but whether the parties have the ability to veto the camera situation. In other words, consent should be required. There are cases, look, most lawyers are like me. They love being on camera, all right? And they love, and especially if you're in private practice, what could be better advertising than having the world watch you perform, presuming you're a good performer? So I would have to balance my ego with my strategy on a specific case as to whether this is good or bad for my client. And that is my job, to ensure that I can insulate this trial to what is really at stake, to what the rules of evidence require, and to avoid any outside influences from impacting the jury. And that's why I think it's an attorney and client strategic decision that is extremely important, because every case is different and every aspect of the case, including whether the world is watching, can influence what a lawyer will advise his client to do or not do.
Yeah. So Dan, we've mentioned that, public access to courts and our justice system is important, but is it more important than ensuring that we have a fair trial, especially when it's involved a criminal matter and someone's life is potentially at stake? Is
Yes.
it more important than that?
Yeah, so those values are not in conflict with one another. In fact, I'm going to argue that they are complementary in a couple of ways. First of all, to my knowledge, there's never been a single a verdict overturned in Florida because the media got control of the case and something went off the rails. So we've had 40 years to see that sort of nightmare scenario play out, and it hasn't. So to take what Norman's saying here and apply it, map it onto the real world, well, you'd have to say, well, look, we've had 40 years of just injustice, flat out injustice in Florida. And I just think that's a big claim to make. And I would want to see support for that. The other part of it is, to Norman's point, jurors we're reading all the time about having very unrealistic views of what they're supposed to see in court. I've read certainly kind of scary articles about how when you're trying to do a criminal trial, they want to see the CSI lab, they want to see the fingerprint technology, all the fancy things they see on TV. So the more that ordinary Americans are exposed to the actual justice system as opposed to the pretend one that we all enjoy, law and order, et cetera, the more realistic and attuned to these rules, these very complicated and confusing rules jurors may be. I think, you mentioned the Amber Heard trial. Hearsay played a massive role in that case. And there's like millions of people now that know what the word hearsay means. So I think that that's great. And then just to kind of hone in on whether or not there's a conflict between defendants' rights and the public access, I reject that, because to me, it's the opposite. I think there's a lot of criminal trials that we'll never, ever hear about. And when a lawyer gets out on the courthouse steps and says there was an injustice done there, who are you supposed to believe? So it plays an incredibly strong sunlight effect to be able to have these trials visible to people, to make sure that justice is being done for these people, because not everybody is able to afford a great attorney like Norman, Effman. There are some overworked, or
I'm free, by the way.
Not everyone has the requisite luck and to find their way with the right person. There are, unfortunately, instances of ineffective assistance of counsel, of things that just go awry. And it's really great because we have our society has changed a lot, and there's a real element of, what's the phrase, Pixar didn't happen. People need to see video evidence of things. And what is frustrating, as many people may have found watching the Kyle Rittenhouse trial or the Amber Heard trial, any of these trials, they saw justice being done, and it helps tamp down on speculation that like sinister things are happening behind the scenes. And on the other side, if there are things that aren't great, then the public will have recourse to watch it. There's a lot of people that love watching, court watching, but they can only be in one place at one time. And this is a force multiplier. Let the media, let the public come in and see these things, watch justice. And my bet is that people will come away actually feeling that the courts are working, but I can't ask people to take my word for it.
Let me, since you both mentioned the Amber Heard, Johnny Depp trial, obviously many people are familiar with that because that one was in fact broadcast, and we had multiple cameras in that courtroom. Let's talk about that a little bit, because that raises another issue, right? So there were the legal issues, but then there was the court of public opinion, right? I mean, I don't know if everybody knows that Amber Heard was actually successful on her counterclaim. In the court of public opinion, she was the loser, because people watched all 6 weeks of that trial, but because of the various snippets that came out, portrayed her in a negative light. So if you're going to have a trial that's now going to be recorded, do you need, in addition to having an attorney, you need to have a media marketing person as well. So even if you win the case and you lose your reputation in the court of public opinion, that's just as bad, sometimes worse.
Yeah, I feel like with the Depp Heard trial, what's very interesting about it is that people have come to their own conclusions about what really happened between those two people. And while I would love for our justice system, the jewel of our democracy, to be the final word on whether or not Johnny Depp was abusive towards Amber Heard or vice versa, it's really great that people can watch this and decide for themselves. And yeah, some people come away with whatever conclusion they want. They could misleadingly edit testimony, whatever. But the reality is that as a condition of people of access to that court TV, law and crime, all the people that care, there is a record that exists online. It's still there. It will be there in perpetuity, that you can watch the whole thing. And so there is a neutral, authoritative record that exists. I am wary of people coming in and getting snippets of things, which is why I think it's so important to have the live streaming element.
Yeah. So let's talk about that though, right? So, we're talking about a couple of different things, right? I mean, I think our technology has advanced to the point where you can have a camera in the courtroom and it's not going to be disruptive, certainly. And you can just press play and let it record, and people can watch it just like if they were sitting in the back bench of the courtroom, and they could watch as much as they want, and they could leave and they could come back. But the problem is when we have the media now taking snippets and people with their own separate agenda, if we're recording everything, they can take a part, maybe out of context, maybe a part that the judge might later say, someone could object, and that objection could be sustained, and direct the jury not to listen to that, not to remember that part of the testimony. that's not going to be in the snippet, right? The embarrassing part's going to be in the snippet, or the incriminating part when someone says, how often do you beat your wife? And then you see the witness, stammering for an answer, and you don't see in the snippet, the judge saying, that question is out of order. Norm, is there some way that we can have the cameras in the courtroom, but also protect against this kind of misleading use of video?
Sure. I mean, they're not.
But the question was to me first.
Oh, sorry, please.
That's all right.
Norm gets to...
Yeah, it's a terrible situation. I remember in the O.J. Simpson case that one of the issues, for example, as to what the media can do to emphasize certain things that aren't real when you take it out of context, is that the photo of Simpson, his mugshot, was darkened in certain papers to make him look more black than in real life, and that was to sell papers or to get across something that, of course, deals with the implicit bias issues that I talked about earlier. The real thing that I have is not so much the public concept of what's going on. Trying to teach people about what really happens in the courtroom. You should start in the second grade and keep working up and let them visit courtrooms and see what's really going on, and then they'll be bored and they'll go home. But the reality is, the human mind, the human condition is so unknown that we've never discussed implicit bias until what? The Floyd case. The same thing is occurring on a daily basis now with what is really impacting that jury in a criminal case, and can a camera impact it where we don't even know whether that's happening or not? I mean, I don't know what's happening in Florida, but I do know that jury selection is more of an art than a science in my mind. There's more science being involved in it every day. And now we've changed our jury instructions to include instructions on implicit bias. Do we have to now include instructions on the camera is there, but disregard it? I mean, I'm more concerned about the rights of my client to ensure that the jury follows the rules of evidence as given by the court, is not influenced by the outside media frenzy on the case, and it's not influenced by what the world thinks. It's what the rules of evidence mandate based on the court's instructions, and can they be followed? And that is such a difficult thing, I believe. You can find out when you talk to jurors after and find out what they base their decisions on, as to how you never imagined that those factors went into what occurred in that jury room. So sure, I'd like to see cameras in the jury room, by the way. That's where I'd like to see cameras.
You're more evolved than I am. Look, it's important to me that the public does not see anything that the jury doesn't see. We're not picking up sidebars. In fact,
it's not so much that it's being fully recorded. It's what is shown. What are the snippets?
No, I understand. But what I'm saying is, if you go to the courthouse, you can stare at the jury and see if they're sleeping, if they're smiling, laughing, crying. Right. If you watch the Johnny Depp trial, you do not know. I would not recognize the jurors. I've never seen them. So they are protected in that way. You're not seeing things that they're not seeing, which is also important. I think that's, arguably as a member of the public sitting in the courtroom, you can overhear things that the jury might not hear. But the important thing is that what is floating around online, out of context video clips, it's irrelevant to the jury. They've seen it. They've seen all the evidence. You're talking about a larger problem, which is sentiment, which is that the potential for an out of context clip. I'll give you an example. During the Amber Heard trial, she presented her makeup compact. And then it became this whole thing because she said, this is the makeup I use to cover up my bruises. And then the makeup company said, actually, we didn't produce that brand back then. It became this real gotcha moment. And I think it was too much made out of that. I don't think it was being presented like that was literally the thing she was doing. Anyway, so could that somehow turn sentiment on them? And then the jury just becomes unconsciously motivated to match what's going on Twitter and TikTok or whatever. We just haven't seen that yet. And I do believe in the ability of judges to control their courtrooms. The jurors have never been, you can never fully isolate them from the world. And clips being one thing, it doesn't seem to be much more persuasive to them than reporters coming out and filing stories saying that Amber Heard got in there today and made up a story about her makeup compact. So it's just whether or not the video is going to affect them affect the public more than just the audio or just the reportage of it. And so it's all very speculative and attenuated. And I believe that jurors actually do take their job seriously. In the Sarah Palin case, there was a push notification, which had nothing to do with video in the courtroom, that jurors unfortunately were exposed to. They said that didn't affect their deliberation. I think that we have to have a strong sense of trusting jurors to tell the truth and to discharge their duties. And if we hear from them that there's too much public pressure bearing down on them, then we have to be responsive to that.
But I think it goes beyond the juror, right? I mean, so even if the jurors can be blocked out because they're going to be instructed, look, don't watch any media about this case. Don't even read the newspaper about it. Don't do anything, right? So let's put the jurors aside. But what about the plaintiff or defendant or the witness that is on the stand and somehow taken out of context and humiliated in the public eye? Not with maybe the jury loves them, but the public, they're going to come out and walk around in public and maybe have it impact their profession or their career or their life. That seems unfair. And how do we protect against someone taking snippets and making someone look like improper or in a negative light?
Well, we have laws. We have false light, well, not in New York, I should say, but outside of New York, we have defamation law. We have, there are remedies for being portrayed in a way that is damaging to your reputation and profession.
It's not false, right? Because it's a true.
Well, there's defamation by implication. I should say, I professionally, I could literally never take one of these cases, but they do exist. People do get defamed.
Can I say where we agree? All right, number one, I remember when cameras during the first experiment or whatever in New York, arraignments especially, presumption of innocence, etc. And people wore bags over their head because of cameras in the courtroom itself, not just the perk walk, but overcoming that taint as being portrayed as the accused, presumed innocent in the law, but not by the public. But where it's successful, for example, I have appeared, in this particular format, virtually. I have watched appellate division arguments. I've been involved in appellate division. Those are perfect for cameras. In fact, they are great to have the appellate division and Court of Appeals material available on camera, on video in archives, so you can see it anytime you want. I would love to see cameras in the courtroom in town and village courts, especially with non-lawyer judges. I think that would open the eyes of not necessarily the public that already knows what a mess that can be, but of the Office of Court Administration and the judiciary generally as to the lack of justice in justice courts. I think the world is closed to that because it is a closed society and people don't. So there are times when cameras in the courtroom are very important. But most important to me is what impact it has on the system itself and protecting the rights of the accused. And I understand we're on the same page, and I understand the studies thus far have shown nothing, but we don't know what's happening in the human mind. We don't know what impacts it. And I don't believe, just from what I've observed, that judges are the same off camera and on the camera. I think every judge is different, but clearly certain lawyers, certain prosecutors, certain defense lawyers, and certain judges are playing to the camera, and it could change decision-making and arguments and alter the very process that we are trying to preserve, and that is a fair trial.
But that cuts in both directions, right? Because maybe judges that are prone to not doing great
in village court, like I said, in village court,
right,
I love them to know the world is watching.
Judges are all human, like the rest of us. They're all tremendously flawed, like myself and everyone else. And it's a question of, it's speculative, but the sunlight has to win in a free society. And the question I will pose to you is, for the Derek Chauvin trial, there were 23 million people that turned into that. How do you fit them all in the courtroom if they want to watch a trial, watch justice? Like, there's no option there. So what are we going to do?
Maybe after the trial.
Well, but that doesn't. Look, if there was a tape delay, I mean, you're talking tape delay, right? That's fine. I don't need access to live justice on demand. The question is, will people be able to watch what happens in our courts? And increasingly, people do. There's evidence people really do want to watch these things. The Derek Chauvin trial is one example. the Kyle Rittenhouse trial had millions of people tuning in prime time. We saw the Johnny Depp Amber Heard trial was millions of people tuning in. Where are we supposed to fit all these people?
Well, we can fit them in after the verdict is in.
I think that's a very interesting proposal. I haven't even considered that, but at least we're in the same ballpark of let's have a record of what happened.
So let me ask you this. So I think we're all in agreement that there should be some cameras in the courtroom because it provides public access to the court system that is good for everyone. I think there is agreement also that there should be some restrictions. What those are, I'd like to ask each of you, where's the balance, right? So Dan, I'll ask you first. How do we balance both of the concerns, public access, fair trial, fairness to witnesses? Where does the balance fall?
The balance to me is safety and wellness. There are people that are undercover informants or officers that we do take steps to disguise their identity. And there's all sorts of things that judges will permit to protect people's identity and safety. If there was some reason to believe that there was more information that could be gleaned on the camera than what is possible in the courtroom, absolutely see to the safety of vulnerable people. And then there's the people I've talked about that are vulnerable in a different way, children, maybe victims of extraordinary violence or who have continuing threats to them. I think you have to look at each individual witness as an individual and see what their situation is and make an assessment as to whether or not the camera, the video recording what they're doing is making it worse for them than mere court watching and public attention to it.
And that assessment, that would be made by the judge in the case, right?
Yes. And in Florida, the judge makes that assessment. I don't know how, I couldn't tell you how often it's challenged, but it's based on good cause. And I think in the vast majority of cases, you won't see the media challenging that. And the reason why I'm skeptical of a sort of defendant veto, I'm totally understand where people are coming from with that, but where do we draw the line? If someday we see a trial of Donald Trump in New York, does he get to decide if it's on camera or not? I mean, I don't know. That could go either direction, believe me. But I don't want to give defendants a veto right because the public deserves to see the justice being done. So I don't mean to be dismissive of these concerns, but to me, they are addressable in the courtroom by the judge. And we as lawyers have to educate the public, educate the judiciary, and work together to figure out how these things work. So there will obviously be a breaking in period and adjustment, but we can collectively get over it because New York is the best and takes backseat to no other state. And so I'm confident that Florida can figure this out, a state that is not renowned for having its act together, that New York can handle it.
Norm, let me ask you the same question. That what Dan just proposed sounds relatively reasonable, right? That the judge would still preside over their courtroom. They could say this particular part of the case is not going to be, there's not going to be public access, which is what they can do right now, quite honestly, with people walking in the courtroom. Where do you think, where would you think in an ideal world that the line should be drawn and the balance should be had? Norm?
Boy, I'm just thinking of the ideal world during the Trump trial that's coming up. But
so in the ideal world, we don't have any trials, right?
Right.
Less than ideal world.
So David, this, as you know, is not a particularly new topic. New York has been experimenting with this on and off for years. I did my own little due diligence when I was asked to appear on this. I don't remember if I was in the House in March of 2001. But as you may know, the Bar Association had a special committee on cameras in the courtroom. I think Vince Bizard was the chair of that committee. They issued like a 300-page report back in 2001. There was only one criminal defense lawyer on that committee, and that was Marty Edelman, who the criminal justice section is named an award after. He passed away in the past 2 years. And he wrote a very long dissent, which was joined by another member of the committee. And they basically approved cameras in the courtroom and listed, I think there were 22 factors that a court should consider in determining whether or not to permit cameras in the courtroom. and that report did not approve a consent aspect of it. It did not have that there. I testified back, I think in '94, in it must have been a legislative commission run by Judge Burt Roberts on cameras in the courtroom. And Burt thought I was in favor of them because I had talked to him about. I practiced in a very rural county, which is 99% white, and I have many clients who are accused of crimes while incarcerated in the two correctional facilities here, Attica being the well-known one. And so I'm often in an all-white courtroom where almost every juror has some connection to corrections, given the employment within Wyoming County, which is basically agriculture and prisons, and defending people of color. And back then I said, I would want cameras in the courtroom to Burt Roberts. I said, because otherwise it's a closed society and the jurors are ignoring what the world might consider realities. I didn't call it implicit bias then, but obvious bias. And if they knew that the world was watching, it could impact jury selection. So there were times I thought that exposing what was going on in the courtroom to the public outside of my community would benefit my clients. But that was a strategic decision. And when I testified, and Burt pushed me on this, I said, however, it requires the consent of the defense lawyer, whose primary interest should be protecting the rights of his client, and there are strategic decisions that have to be made. I think that if you look at the report from 2001, all of the factors that Dan mentioned are in there as to what a court should consider, including protecting witnesses, protecting law enforcement. All of those are part of, but it's 21 factors. And I don't know how many judges we have. I'm sorry, I have to rely on competent defense lawyers to make decisions in the best interests of their clients, which in my mind is paramount, and that should be the focus of criminal justice, especially. But this new legislation opens up family court to cameras in the courtroom. My God, if you think the Johnny Depp thing drew attention, come to any family court. I stay away from family court. It's too violent. I need criminal court. Okay. So I think there are times that when emotions are so raw that the fact that it's being broadcast, and who's broadcasting it? It's only going to be broadcast if it's commercially positive for whoever is putting it on television. They're not going to show what happens to your DWI ticket when you appear in the town of Warsaw. They're going to show the Johnny Depp type of situations or the high-profile criminal cases. And there is where you need the most protection for the individuals involved in the trial process. And simply giving the realities of the human condition, I want to make a strategic decision as to whether cameras are beneficial or not to my client.
Yeah, well,
so I just wanted to. I'll give Dan the last word here. But so Norm, you've went through the New York State Bar Association's report on cameras in the courtroom, and that's actually the current policy of the association. And you believe that stands the test of time. I mean, that was 20 years ago. In technology-wise, is a lot has changed, right? And so, but some of our reports are classics, right? They're gonna be good for 100 years. But I'll let Dan just respond to that briefly. Norm's thoughts on where the balance should be.
I really respect that a defense attorney is looking out for their client's interest. That is absolutely what you're supposed to be doing. But it's only one part of the equation, and we have to look after the system too. And so if you leave it in the hands of the attorneys, then it becomes a strategic decision. Johnny Depp's lawsuit against Amber Heard reflects a strategic decision to try it in Virginia, which I will say, that case did not belong in Virginia. Neither of them are from Virginia. Because one, it's been speculated that they thought libel law was better there. I think that's sort of misplaced, but the bigger factor was cameras. And so I don't want the public's attention being decided for strategic reasons. I want the public to be able to watch everything. And I I say we have to let in the bad with the good, and there are downsides. There surely are. There are people that are going to have vulnerable moments in court that may have only been seen by 3 elderly people that like to watch, on Thursday afternoons, and instead it lives on a server somewhere. So I'm very cognizant of that. But ultimately, we have to look after the system, and our country's faith in courts is just plummeting. Now, you can ascribe a lot of that to the Supreme Court, but I don't know if people are really distinguishing tremendously. And so I'd love to see people to see the courts. And if they are pleasantly surprised that they're mostly running well, or running okay, I should say, that's great. And if they're seeing more that they don't like, then even better, because then there may be some impetus to clean things up and have better systems in place. So I think I'm just going to say that I agree with what you're saying, but I'm going to say that you're still on my side.
Okay, so listen, I think we've found some common ground. This might be a good time for us to wrap it up. Dan Novack and Norm Effman, I want to thank you both for your insights on this very important issue. I'd like to thank you both for being with us here on Miranda Warnings. We have something of a lighthearted feature on Miranda Warnings. I'll give you each a brief opportunity. We have something called Music, Book, or Movie. You can share something of interest to you with our listeners. It doesn't have to be about cameras in the courtroom. It could be any book or movie or music that means something to you. So Dan, what do you have for us?
This is my hot take about Miranda Warnings, which is that the whole notion of Miranda Warnings, which is what the last 60 years of jurisprudence, is that you could ever knowingly, intelligently, and voluntarily waive your right to be quiet or have a lawyer. And any lawyer will tell you you're an idiot if you don't exercise that. So I wasn't exactly happy with the status of Miranda before this week. So I think we have some work to do to address that shortfall.
Well, we all want to make Miranda better.
I think everyone should just be allowed to be quiet, and there's no harm in letting people know that that's their right. Innocent people, guilty, there should be no distinguishing in that.
I think by making it a right, maybe more people will think it has some value.
Mm-hmm. And then as for my plug, I don't know if you can see Zabar's here, but this is perfect for our New York listeners set. It's a biography of Zabar's famous supermarket and delicatessen on the Upper West Side. You can have a copy. You can have you can get the book there. It's a very good book, and you can also have like a smoked meat shipped to you, I think, like anywhere in the United States. So I would urge all listeners to get their smoked salmon before, whatever the next holiday is.
All right. Thank you, Dan. Norm, any thoughts on smoked meat?
Yeah, we have found common grounds. I did grow up in Brooklyn and Long Island. So yes, there's a part of my heart and soul is with that type of delicatessen that is difficult to find these days. I go to movies for entertainment. I mean, there are a lot of good movies, and I was just thinking about this. I like the old Woody Allen stuff, before he became the pervert, whatever. Right? I thought his early stuff was just great, and then some silly stuff like Slapshot. I can watch Schindler's List and stuff like that, and I get emotional about that stuff, but I need some entertainment because my life is serious enough. So give me some 1975 Woody Allen movies, whether it's Annie Hall or any one of them back then.
Very good. Norm and Dan, thank you both for your time. Thank you for being on Miranda Warnings, and we wish you both the best. Thank you.
It was a pleasure, David. Thank you.
As for my plug, I don't know if you can see Zabar's here, but this is perfect for our New York listeners set. It's a biography of Zabar's famous supermarket and delicatessen on the Upper West Side. You can have a copy. You can have you can get the book there. It's a very good book, and you can also have like a smoked meat shipped to you, I think, like anywhere in the United States. So I would urge all listeners to get their smoked salmon before, whatever the next holiday is.
All right. Thank you, Dan. Norm, any thoughts on smoked meat?
Yeah, we have found common grounds. I did grow up in Brooklyn and Long Island. So yes, there's a part of my heart and soul is with that type of delicatessen that is difficult to find these days. I go to movies for entertainment. I mean, there are a lot of good movies, and I was just thinking about this. I like the old Woody Allen stuff, before he became the pervert, whatever. Right? I thought his early stuff was just great, and then some silly stuff like Slapshot. So I can watch Schindler's List and stuff like that, and I get emotional about that stuff, but I need some entertainment because my life is serious enough. So give me some 1975 Woody Allen movies, whether it's Annie Hall or any one of them back then.
Very good. Norm and Dan, thank you both for your time. Thank you for being on Miranda Warnings, and we wish you both the best. Thank you.
It was a pleasure, David. Thank you.
This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.